to our Tenants' Rights.
Thank you everyone for coming out today to our Tenants' Rights Town Hall. This is a really important topic. I'm excited to have you all here today. The person who will actually be doing the presentation is Phyllis Katz with CRLA. So can we get a round of applause for Phyllis? Alrighty, thank you for coming today. The purpose of this town hall is to really make sure that our community understands their rights and obligations as tenants, and that the community understands what the obligations are of the landlords as it relates to having a healthy and safe living environment. The reason I wanted to do this town hall is because we're having a lot of conversations about our housing crisis. But it's important to recognize that our housing crisis is multifaceted, and it requires a public policy discourse that recognizes the complexities of the challenges that cause our housing crisis. Now, what do I mean by that? Yes, there is an issue of housing affordability, but we also know that far too many families are living in substandard conditions and have a legal right to the housing that they live in, but unfortunately, due to lack of available knowledge about their rights, they are being evicted. And so if we really want to fundamentally address our housing crisis, it starts with keeping people housed and making sure people have access to housing. Because we recognize here today as a community that housing is a fundamental human right. So thank you all for coming out today, and there will be an opportunity to go over this presentation, and at the end we will have questions and answers, and so that'll provide any clarity on anything that was not clear. But thank you all for coming out today, and without further ado, I'll pass it over to Phyllis.
So I have been doing housing law for about the last 35 years, and I hope that I will be able to share some of the tenant rights with you. I also want to share something building on what Mr. Rocha touched on, and that is that this is a time not only when the city is looking at housing rights, but all of our Monterey Bay area governments are revising their housing elements. So the city of Salinas, the county of Monterey, and all of the jurisdictions are revising their housing elements. The housing elements require that each jurisdiction identify land for low-income families, for farm worker families, for disabled people, for elderly people, and I think there's several categories. And what is required is that the cities and the jurisdictions do outreach and invite the community to participate. And what I want to encourage you to do is participate. They really need to hear from people, and it's important that the city not only says what they want to build, but actually identifies land to do it. And there are legal remedies that can be taken against a city or a jurisdiction in the event they fail to do it. So here I am, invited by the city and the generosity of the city, and letting you know your rights as against the city. So that's the hats that I tend to wear. So I want to start by saying that tenants have rights and they also have responsibilities. And so with respect to the responsibilities, why don't you tell me, what is a tenant's responsibility in a rental housing, in a rental unit? En cualquier idioma.
To pay the rent on time.
To pay the rent on time, thank you. What else?
Cuidar la propiedad.
Take care of the property. Correct. Thank you. Anything else? What about reporting problems with the property? What about if there's a problem with the plumbing? Does the tenant have a duty to report it? Why? Any ideas?
Porque si no lo hacen a tiempo se va deteriorando más la la propiedad, porque a veces y muchas veces no hacen caso de una fuga y cuando quieren ellos repararla ya es más.
Because you have to address the problem timely, because if not, it can get worse.
So many tenants are afraid to report problems to their landlords. And in fact, not only do they have the right to get repairs, but they have a duty to report the problems to their landlords. So that a leaking window, or a door that doesn't seal well, or a leaking roof, or a plumbing problem that's perhaps leaking, or a loose toilet can be repaired in a timely manner before there's further damage to the property. So this presentation is to offer general information about tenant rights, and not to address anybody's specific legal situation at any time. And there are a lot of details that go into any individual situation. So we would encourage anybody to make sure that you consult with somebody knowledgeable in the law before thinking that you have the whole realm of the law presented here. So we're going to go over a number of issues today. We're going to talk about the rights of tenants. We're going to talk some about eviction. We're going to talk about the right to ask for repairs and get those repairs and habitability issues. We're going to talk some about rent increases and limits on rent increases. We're going to talk about security deposits and discrimination. So I'll get through as much as I can while everybody still seems awake. So who's considered a tenant? So a tenant is someone who lives in an apartment, a house, or any space that they pay rent for. Or sometimes there's tenant acceptance, or there are different times when somebody isn't paying rent and they still have certain rights. There are different types of tenancies. Some are verbal and some are written. A verbal tenancy is every bit as enforceable as a written tenancy. So if somebody you know is living in a unit and they don't have a written rental agreement, they still have rights. Okay? If there is a written rental agreement, it might be for a year, it might be for 6 months, or it might be a month-to-month rental agreement. Those rental agreements, especially those in writing, it's really important to know what's in there. Because as you read through them, you might find that there's a late fee that applies to rent if it's not paid by a certain day of the year, of the month. It's important to know what utilities are the tenant's responsibility and what utilities are going to be paid by the landlord. We're seeing a lot more rental agreements in recent years where the landlord is charging for sewer and garbage and water, things that were previously encompassed in the rent. And now I'm even seeing charges for using their online portal to pay the rent. I'm not sure that's legal. Have to figure that one out. ¿Jesús?
Una pregunta. El bill de utilidades como basura, como agua, ¿el dueño puede incluir el bill de utilidades con la renta en un solo bill o tiene que mandar el bill aparte del agua y basura con la renta? ¿Es separado o si es legal que vamos a decir 1.850 la renta más 50 del agua? Son 9.900 tienes que pagar. ¿Es correcto? legal?
It depends. So again, it depends on what the rental agreement says. So the rental agreement, some rental agreements say that all of these utilities, if unpaid, are part of the rent. Most don't, but I have seen those that do, so that any of that all gets encompassed in the rent. Usually, what we're seeing is that a landlord will bill separately for utilities and separately for rent, and then they may give, if both are not paid, they may issue 2 3-day pay or quit notices, one for the rent and one for these other charges under the rental agreement, such as the utilities, perhaps parking, perhaps a pet fee. So there can be all kinds of hidden charges in your rental agreement that can actually increase the monthly costs by hundreds of dollars a month. So it is really important to make sure that you read through that and know that. Yes?
Yo tengo una pregunta referente a lo del contrato. Yo, por ejemplo, ya tengo 14 años viviendo en la misma casa y ya tiene como unos 3, 4 años que ya no estamos haciendo tanto contrato. ¿Es legal o no es legal?
Okay. So one thing again, I want to make sure that I'm staying away from giving advice to any particular person or on any particular issue in this public forum. First of all, because attorney-client advice is privileged, and I want to make sure that it's only given in a context where it's kept confidential. So I will answer in general. So oftentimes, if there can be a 1-year lease, and that covers the first year, and there can't be any rent increases during the lease time, and then it says that it'll continue month to month thereafter, and once there's rent paid. So rental agreements can continue month to month thereafter. The presumption is month to month. Sometimes there's hotel rental agreements where it gets different, where a week is paid at a time, and it gets complicated, so I'm not going to go there right now. But generally, contracts continue while the rent is being paid. I also want to point out that there can be charges for pets, but there can't be charges for service animals or emotional support animals. And there's a very important distinction. My dog looks the same whether it's an emotional support animal, who my medical provider recommended that I get an emotional support animal because I'm suffering from anxiety or depression, and my medical provider thinks it's a good idea for me to get out, and that if I have my dog, that I will get out and walk more. And that's different from the same dog that is a pet. And for a pet, I can be charged, and for my emotional support animal or a service animal, I can't be. So, and that is because an emotional support animal or a service animal under the fair housing laws is no longer a pet. Okay, so very important. And a landlord who has a no pets clause is still required to accept an emotional support animal or a service animal as a reasonable accommodation to a person with a disability. Question?
So earlier you were talking about this laundry list of how they're charging extra fees, and there's most likely other things that are being done that are not quite kosher, right? Is there some way that the legislatures, like the city, the county, can maybe do some rent control to address that, to make sure that they don't step over the line too far?
there are steps that local government can take, and then there are things that local government is not able to do. And so the answer to that is it depends. There has been a long time law, Costa-Hawkins. So it has made it very difficult for local jurisdictions to pass rent control unless they did it like pre-1970 something.
Was that what you mentioned, a state issue that you just mentioned? Yeah. That's a state issue, right?
So to answer that question a little bit, there is a state law that was passed, I believe, in the 80s by Jim Costa, who was in the state assembly, and there was a senator with the last name of Hawkins, and that law is known as Costa-Hawkins and limits local government's ability to apply rent control measures to single-family homes and units built, I believe, after 1995. And so, but it also does allow for local governments to enact rent control measures with certain limitations that do not apply to either of those specifications. So in short, local governments do have the ability to enact rent control, just with limitations on it.
And generally, the payment of rent should be able to be made within 3 days without a penalty. Very important is that every tenant has the right to get a receipt for payment of rent, and it can be a written receipt, it might be through an app, but there needs to be some way of showing that you've paid rent. And I can hardly tell you how important this becomes in our office and how often tenants come in with a notice to pay or quit, and they say, but I paid some of this. I know I paid some of this. And they have, but there's no proof that they paid it. There's more than a few landlords out in the community who aren't perhaps declaring their rental income, and they're not perhaps declaring their taxes legally, and they don't want to give a receipt for the payment of rent. You have the right to go to have a little booklet and say, just sign here that I paid the rent. Sometimes I suggest, take a picture of the cash that you're laying out each month, that you're paying the rent to the person. Keep your own records of when you paid the rent and how much you paid. This doesn't have to be really neat. It can just have a date, the amount, and who received it. Was it the manager? Was it the landlord? Was it the daughter or the son or the son-in-law? Who took that money from you as rent? Because your business records of your own payment are not as good as a receipt signed by a landlord, but it's something, and it gives us something to go on, and it will be seen by the court as some evidence of payment. So this is really important. You have the right to pay in cash or money order. You can pay with your check unless there's some requirement in the rental agreement that you can't. And you could also send a text message to the landlord each month. This confirms that I paid you X amount on such and such a date. Please reply if this is not accurate as to the amount that you did receive. So there are ways to kind of put the burden on the other side to, you tell me that you didn't get it. And then we'll address that now rather than waiting until there's a conflict. Because it's much harder to work things out once there's a conflict already brewing. Okay, rent increases. So So if there's a contract, so say there's a 1-year contract between the landlord and the tenant, the landlord cannot raise the rent during that period of time. Is there a question?
Yo tengo una pregunta acerca del late fee. Hay muchos apartamentos que cobran como quieren el late fee. ¿Hay una ley donde pueden estipular un porcentaje cuando pagas tarde la renta?
I generally look to make it's now that rents are so high, the late fees seem to be going up proportionately. At a certain point, a self-imposed fee like that becomes I think it's called a civil penalty. And at a certain point, civil penalties aren't allowed. And so the question is, when is it too much? Certainly if it's more than 10% of the rent, there's a strong argument that it's too much. If it's, I haven't seen it as much lately, but there have been some late fees that would increase, they would start on the 3rd or the 5th of the month, and they would increase $50 a day or something. Those always, we always felt very comfortable sending letters saying, no, you can't do this. That's not in any way reasonably related to the expense that the other party incurs as a result of the late payment. So at some point, yes, and exactly where that line is, it's a little bit hazy. So hard to give a definitive answer on that. So I'm going to talk about 3 separate parts of the law, and this is just kind of difficult to follow right now, and I'll try to differentiate the 3 different pieces of the law that I'm going to talk about as we go through them. So this is the basic law. This is the plain old peanut butter and jelly law. That if there's going to be an increase of the rent of more than 10% or less, then the owner or landlord needs to give at least a 30-day written notice. If the rent increase is more than 10%, then, and this is not accurate, it should say 90 days written notice. Then the landlord has to give 90 days written notice. I apologize for that. But you're going to keep listening because I'm going to tell you that right now the landlords can't raise the rent more than 10%. But if they could, and there will be a time again when we're outside of emergency status that they're going to be able to, but that third bullet point should say 90 days. Okay, so this is the very, very basic law. This is not the Tenant Protection Act. Under the Tenant Protection Act, there is, this is law part number 2. So law part number 1 is that for a rent increase of 10% or less, 30 days notice, over 10%, 90 days notice. Okay, that's part 1. Keep that part in the back of your mind. Now, along came the state legislature in December of 2019, right before we hit the pandemic. And the state legislature passed a law that says, if you live in multi-family residential housing, you have and the housing is more than 15 years old, then the landlord can't raise the rent more than the consumer price index plus 5%. Okay, so that has to do with, you have to look up the consumer price index, you have to figure out what's the consumer price index plus 5%, and, said the legislature, you can't raise the rent in multifamily housing more than 10%, unless you can really show that you had an expensive year. You had to do major work on that unit. And then you need to justify it. You need to amortize it over the life of those repairs, blah, blah, blah. You have to jump through some hoops to go above the 10%. Okay, so that's law number 2. Right now, under the Tenant Protection Act, if you live in multifamily housing, it just so happens that because inflation is so high, the amount of the rent increase is that the maximum rent increase can be 10%. So we're still kind of at this 10% figure, kind of in various modes. So but the Tenant Protection Act applies to multifamily apartments. It also applies to housing. Some people might know someone who lives in housing where there's a garage rented out and maybe there's another unit rented out, and or even just one additional unit rented out and the owner doesn't live on that property. The Tenant Protection Act applies. The Tenant Protection Act doesn't apply if the owner lives in one unit and there's just one additional tenant on the property. Then that property is treated as single-family home. It doesn't get the protection of the Tenant Protection Act. In addition to putting some limits on the amount of rent increase that landlords in multifamily housing can do, there's also restrictions on when a landlord can terminate those tenancies. They need to either state that they're terminating for the tenant, something the tenant did wrong. So they're terminating because the tenant is holding too many parties and causing a nuisance, or doing some kind of illegal activity in the unit, or doing something else. And then they can terminate the tenancy. So here's where it gets complicated again. If it's really something like selling drugs, they can terminate for 3 days with a 3-day notice for committing nuisance. If the tenant is really destroying the property, they can terminate the tenancy with a 3-day notice for having damaged the property. However, normally the landlord has to give either a 30-day notice without cause if the tenant has lived there less than a year, or if the tenant has lived there more than a year. Under the Tenant Protection Act, they need to terminate with 60 days. If it is not due to the fault of the tenant, then the landlord has to waive 1 month's rent. So they either have to waive the last month's rent in the 60-day notice of termination of tenancy, or they need to return a month's rent within 15 days of serving the notice. That's a mouthful. That's a complicated law. We were just barely learning it when COVID hit, and then the laws kept changing again. Okay, so let me really briefly go through it again. So it put in place just cause eviction for tenants who live in multifamily housing. It put in place a right to a month of rent returned if the landlord was terminating the tenancy for their own reason. And it put in restrictions on how much the landlord could raise the rent to be no more than 5% plus the consumer price index, I'm sorry, to 5% and no, plus the consumer price index and no more than 10%. Did a lot of things. It was a really major overhaul of California's landlord-tenant laws. The reasons that a landlord can terminate the tenancy for their own purposes is if they either want to take the property off the market or if they want to do substantial rehabilitation of the property. And substantial rehabilitation of the property means that it's going to take more than 30 days for them to make the repairs, and that the repairs are so extensive that they have to pull permits. So if they serve a substantial rehabilitation notice on a tenant and they don't pull permits, and it doesn't take them more than 30 days to make those repairs, they have violated the law. And that tenant who was displaced has a claim against that landlord for an unfair business practice and for abuse of the legal system. Okay, those are two laws. So we've got what it was kind of before the Tenant Protection Act, rent increases, how much time, and for single-family homes. Then we have the Tenant Protection Act said, hey, if you live in multifamily housing, we're going to put all these additional protections in place. So there's a penal code section, 396. It says that when there has been a declared state of emergency, you can't price gouge. And what it says, and it specifically says landlords can't price gouge. So landlords cannot raise rent more than 10%. This applies whether it's single family, whether it's multifamily. This is across the board. There is this exception if they can prove that they had to put in a whole lot of work to the unit, blah, 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 then they can say that they needed to raise the rent more. But otherwise, they can't. And this has been in effect since the governor first declared a state of emergency for COVID on March 4th of 2020. And more recently, the governor declared a state of emergency that covers the entire state. And that's in place until July 3rd of 2023. We should probably look because there may be some extension because of the current storms. This was the initial storm declaration was in January, so I don't know whether now that the storms have continued until March. It might be beyond July 3rd. But there's a website on the Office of Emergency Services, State Office of Emergency Services, and you can look and see what declared states of emergency are in effect at any given time. So any questions about rent increases? Not specific to your housing, but general questions about rent increases?
Tenía preguntas sobre la anterior, sobre unidad familiar y multifamiliar, pero ya lo dijo todo ya está. Y eso es más nuevo.
Okay. Jesus is my plant because he used to work on it.
Why 10%? That seems high. I know in Washington it's 3 to 5%, Washington State. So what's 10% to me seems excessive.
Well, yeah, I mean, talk to your government people. Talk to the electeds. We all have the right to do that. I will tell you that compared to the rent increases of 30, 40, and 50% that we were seeing in 2018 and 2019, I'm personally relieved to see this. I understand your point, but
I I mean, our bosses don't raise us 10%. Yeah, right.
And I want to start off by saying this is my own view, not the view of CRLA, to be clear. So I have some flexibility in my capacity. So what I'll tell you is that the need to have tenant protections and more specifically limitations on allowable rent increases has been a fight that has been waged by community groups for decades. And unfortunately, it didn't culminate up until recently to where the amount of support was able to be garnered at the state legislature to enact this. And so the 10% was essentially at the time a compromise because the groups said no. The groups that were opposing that legislation said no, we don't want any limitations on rent increases whatsoever, and that was the compromise that was reached at the time. And it's also important to note that this particular bill that puts the limitations on rent increases has an expiration date. I don't remember it off the top of my head, but that was also part of the concessions and negotiations as part of the bill. So
there's a violation against the landlord. It's actually a criminal penalty that can be brought by the district attorney, and there can be it's a misdemeanor punishable by imprisonment in county jail for not more than a year, by fine not more than $10,000, or both fine and imprisonment. So raising rent in excess of 10% when there's a declared state of emergency actually has some realty. And the law specifically says that it's also an unfair, it's defined as an unfair business practice under the and an act of unfair competition, meaning that the tenant can also sue. So there would be a claim for the additional rent that tenant has to pay, etc. So this is a pretty strong law, and if anybody has had rent increases or know of people who have had rent increases in excess of 10% per year since March 4th. So it is per year, it's not the entire 3-year period.
The Tenant Protection Act that established the limitations of rent increases was a 10-year law, and it expires in January 1st of 2030. So.
Okay, so we were talking. So now we've just been talking about limitations on rent 2 and 3. So I was talking about 3 in terms of the governor's proclamation and the penal code. Mr. Rocha was talking about 2, the Tenant Protection Act and the limits on that. And also, but I want to point out that, so it's 5% plus the Consumer Price Index. When the law first went into effect in 2020, the maximum rent increase was 6%. So it was 6% for a while, and then it was, I think, 9% for a year. Right now it's 10%. If inflation goes down, it can go back down also. So it's variable and can change. Hopefully, repairs and conditions that diminish habitability. So these are the conditions that a landlord has to maintain. A landlord has to maintain the heat. A landlord has to maintain the plumbing and the electrical and good, safe repair. Landlord has to make sure that nothing is leaking, the walls and ceiling aren't leaking, the windows fit, the windows open and close, and that actually is a fire safety code issue, as well as habitability, and also that obviously that there's no infestation, and that there's garbage pickup and the like. So who pays for the garbage can vary, but there has to be some kind of garbage pickup. So what can the tenant do if something is missing? Let me go back. So if something is not done, then the tenant should notify the landlord in writing. Okay? Ideally, this is I'm old school, in case you haven't noticed. Ideally, this is a piece of paper that you write down, you know, here's what's wrong. Take a picture of it with your phone. Have to keep copies. Keep copies however you can. Picture on your phone is great. Lots of times we're seeing texts to landlords. It's fine. We'll print them as long as it's clear what date you're saying something is broken and that you're asking for repairs. Okay, so that the landlord is on notice in writing that you asked for something on a particular date. When it's not. So many times we have tenants come to us and say, well, I asked for them to repair this many times. Every time I paid the rent, I asked them to make the repair. If it's not in writing, it doesn't exist. Okay, so many of our rights, if it's not in writing, we just can't prove it happened. Yes, you know, a tenant's testimony in court is important, but, you know, the court's going to also hear the landlord saying, he never told me. I never knew anything about that. They're raising this now at court for the first time, and, you know, I had no notice of it. And so, in writing, please, you know, oh yeah, I took a picture of it on the same day I paid the rent and on the same day that I gave it to the landlord. Yep, just kind of knowing what you did, knowing that you communicated it. Oh, and then the next month I did it again because, you know, they still hadn't done it. Or 2 weeks later, I told them again, hey, you know, when is the person coming out to repair the plumbing? When's the person coming out to repair the heat? Don't have to wait a month. This can happen in shorter increments. There are remedies if the landlord doesn't do it. I will tell you that our office is very conservative when we give landlord-tenant rights information, because I want a case that I can go in front of the court in Monterey, at 1200 Avejito, and I can win that case, and my client isn't going to be evicted. Okay? I don't want a messy case where, I don't know, I'm kind of gambling with the tenant's housing. Okay? I want a clean case. I want, when I or my staff walks into court, we want the judge to know there's a case here. There's something that I better listen to because these tenants are well represented. So what are the things you can do when you have a habitability problem and it's not being addressed? One is you can call code enforcement. The city of Salinas has their code enforcement. The county of Monterey has their own code enforcement. Other cities use the county code enforcement. It's either the Department of Environmental Health or the building department, depending on what jurisdiction you're dealing with, who will go out and make the inspection and issue a notice to the owner to make the repairs. What's the risk? So one risk is that if your place is really in bad condition, they might agree with you that this place is really in bad condition, and they might say, you know, this is really uninhabitable and it's unsafe to be here. So they might red tag it. It doesn't happen very often. The city knows that they don't want to be red tagging very frequently because they don't want homeless people, but it can happen, and so it is something to be aware of. Repair and deduct. So after the landlord is on notice that there are repairs that need to be made, a tenant can use a remedy in the code called repair and deduct. And that means that they use a month's rent, no more than a month's rent, to make the repair, and then they deduct that from their next rent payment, and they provide a copy of the receipt that they paid to get that repair made to the landlord. Okay? So you have to make sure you use a licensed repair person to make the repair, who can give you a good receipt as to what their hourly fee and what the repairs cost. And it is, all of these rights are only to be used, other than calling code enforcement, after you've given proper written notice to the owner. Okay? So, and in a reasonable time to make the repair. The code says that for most situations, a reasonable time is at least 30 days. For some things, if the hot water heater's out, maybe it's, maybe a week is more than enough to not have hot water, right? So 30 days is generally a reasonable time to have given notice, but it might be less depending on the situation. So that's repair and deduct. Has to be done right. Anytime you're withholding from rent, if you don't do it right, there's a risk that there's going to be an eviction, because you're going to get a 3-day pay or quit, and we want to make sure, again, that you can win that and remain housed. Withholding rent. This is something that is for very serious situations, and generally our office would say, we want to, if there's rent withholding, we want to make so sure that this is right. We're likely to send one of our staff out to take pictures, and we're likely to ask that our client put their rent into our client trust account so that we have that rent, whatever amount that the judge ultimately decides is due to that landlord. Because what's going to happen is the landlord's going to issue a 3-day pay or quit. We're going to need to be ready to go into court and defend a court eviction action after the tenant gets the court papers. And we need to be able to prove the conditions of the premises. And when the judge determines what's the fair rental value of the premises and the condition they're in, we need to be able to make that payment to make sure that payment gets made within the time that the court says. So they usually say that it needs to be paid within 48 hours, maybe as much as 5 days, usually less. So that money has to be there and ready to be paid, because otherwise we've just gotten prepared to go to court, we've done our best, and if we can't save that tenancy, it's all for nothing. That tenant just lost and has an eviction on their record, and it's the same as if we didn't do that. So in Salinas, in Monterey County, for all of Monterey County on my staff, I have 1 community worker, I have 1 law grad, and I have 1 barred attorney right now, as well as myself, but I also supervise Santa Cruz and San Benito counties. So I have to limit the number of cases that I have on my caseload. So we don't have a lot of capacity, and our office has to be a little picky. We're going to represent the cases we can win, and we're going to make sure that it's set up right. So when somebody comes in, they say, I've got these problems, we're going to go out and get the photos and make sure it's done right. Sometimes the place is just really in terrible condition, and so the tenant wants to just leave, just let me out of here. It's just bad, I didn't realize it was going to be that bad, and they want to leave. Some of the new some of the larger landlords around actually have fees if you leave early for breaking the contract. So you need to, again, know what's in your contract, know what it's going to cost to even just abandon and return the keys. Sometimes there are charges that they can withhold from the deposit or withhold otherwise. So that's repair and deduct. I was also asked to talk about when a landlord wants access to your unit. How much time do they need to give? How can they do that? We doing okay? Okay. Appreciate that. What is your name again?
Anna.
Anna's here translating, and just really want to acknowledge, and I asked her, when can a landlord come in? Mr. Rocha asked me to go over this. Some landlords want to abuse this right, and they want to just kind of walk in whenever. A landlord has to give 24 hours written notice. Here I am changing the law right now. 24 hours written notice before they have a right to enter the premises. They also only have the right to enter for certain reasons. One is to make necessary or reasonable repairs. Another is if they're invited by the tenant. And a third is if they are in an event of an emergency. Sometimes landlords want to come in just to do an inspection. If the tenant lives in subsidized housing, those inspections are permissible. If the tenant doesn't live in subsidized housing and it's not in the rental agreement, the tenant has the right to just enforce the law. The landlord doesn't have the right to just come in, make an inspection from time to time. Sometimes it's worthwhile. Sometimes the landlord really does just want to look under the sinks and make sure nothing's leaking, make sure everything's working okay. But the tenant only, knowing what's in your rental agreement, coupled with knowing that the landlord only has these very limited rights to enter under state law, and must give at least 24 hours written notice. As a reasonable accommodation to somebody with a disability, they might need longer notice. Every rule, policy, and procedure is subject to the laws of to request a reasonable accommodation, and if it's based on a disability, then the landlord needs to comply with those changes to their policies. Any questions about landlords coming in? Is this?
La noticia de 24 horas, ¿eso aplica a las casas individual también o aplica a apartamentos o edificios? ¿Dónde aplica esa noticia de 24 horas para entrar el dueño?
El aviso de 24 horas? Okay, so the question is, when does the notice, to what housing does a 24-hour notice apply? It applies to everything. That applies to multi-unit housing, it applies to single-family housing, it applies to everything. Yeah. So if there is a reduced fair rental value of the premises, sometimes tenants sue through small claims court. So sometimes the tenants want to sue for the reduced rental value of the premises and the condition they're in. They can sue for up to $10,000 in small claims court without an attorney. Also, if they want help, so we always recommend taking photos of the damage of the problems. Take photos of the damages. Keep receipts for costs if you have to eat out, stay in a hotel, or have belongings are lost, and keep copies of notices with the dates and the like. And I'm not likely to make it all the way through the eviction process. So 3-day notices can be used to pay or quit. They can also be used if there's illegal activity in the premises. There can also be notices to a tenant to vacate. Again, now this is complicated because it depends whether it's multifamily or single family. So all of that becomes much more complicated. What I do want to say though is there are also 60-day notices apply if, in general, if a tenant has lived in the premises more than a year. If the tenant has lived in the premises less than a year, they can be evicted with a 30-day written notice. All of these are written notices. A landlord saying you need to be out by March 31st, that's not a written notice, okay? If the tenant lives in subsidized housing, they may have a right to a 90-day written notice. The court process, I'm just going to say there's a right to a court process to complete an eviction. Self-help eviction is not allowed. A landlord cannot turn off the lights, turn off the water, change the locks, do something along those lines in order to get a tenant to leave the property. That's called self-help eviction, and that is illegal. And we do recommend that tenants call the police, and I will say that the police and the sheriff are generally, not always, but generally very good. And if the tenant says, my landlord has changed the locks on the door, or is trying to get me out illegally, or if the landlord calls the police and says, I told them to be out by this date and here they are, they're still here, the police know that they don't do evictions. And when the tenant says, there is no court order and the sheriff has not been out and I live here and my belongings are inside, the police will tell the landlord to back off and to let that tenant in. Now we have had problems in the past, so what we do if there's a problem with the police is we recommend that the tenant ask to talk to the watch commander, who is a sergeant who is always on duty when there's police in the field, and explain the situation, and the watch commander should resolve the problem. So this is what court papers look like, the left side. Pay attention to court papers. Pay attention to all legal papers. Please open your mail, open envelopes, pay attention to notices from the landlord. This is important. You can end up having a sheriff's notice on your door if you don't pay attention to the papers. It's important. I wouldn't be saying it if it didn't happen and if we didn't get these cases in our office often. Please, pay attention to papers. Just like your papers, just like I'm saying to make sure you give papers to the landlord and that you make sure to keep a copy. Paperwork given to you is for a reason and is important. When you get a court paper, a summons with respect to an eviction, only 5 days to file a response in court. This used to be 5 days until recently. It was 5 days counting weekends. Now they've made it 5 business days. So not counting Saturdays and Sundays or court holidays. So actually, it doesn't sound like much, but it's a huge improvement because it's 1 full week. So the answer needs to be filed within 5 days. The answer is your opportunity to say why the landlord is wrong in their court papers. And to declare under penalty of perjury that it's wrong. Then after you file an answer, the landlord is going to ask the court to schedule a court date. The tenant will get a court date in the mail. Again, important letter from the court giving you the court date. The tenant has to be there. The tenant has to go and state their reasons and state their claim, declaring under penalty of perjury what's correct, and very important process if they're going to save their tenancies. Deposits, security deposits. So the security deposit can be up to 2 months of the rent for an unfurnished unit, or we don't have many furnished units in the area, but it can be 3 months of the rent for a furnished unit. That means that normally a tenant is paying can be required to pay 3 months of rent in order to move in, their first month's rent and a security deposit that's up to 2 months of rent. It's a lot of money these days. And so that's something that hasn't changed in many years, how much of a deposit a landlord can accept. The security deposit can be used for unpaid rent, repairs to damages caused by the tenant beyond normal wear and tear. So what's normal wear and tear? Well, it's going to be more if I live in a unit for 10 years than if I live in a unit for 1 year, right? So normal wear and tear is expected, but damages beyond that can be deducted from the security deposit. Again, always a good idea to take pictures before you move out in order to have documentation with respect to your security deposit. The security deposit needs to be returned within 21 days of the date that the tenant vacates. Vacating includes returning the key, and it should be a written letter, and it should itemize the deductions from the security deposit, and should return any of the remaining money to the tenant. If the tenant doesn't get back what they think they should from the security deposit, small claims court is an excellent place to go. So if the landlord is saying the unit was, I had to clean everything, and the tenant can show pictures like everything was clean, they've got pictures of every unit. I always say these aren't pictures to show the grandkids, these are pictures that you just need to make sure you have. The inside of the refrigerator, if you clean the oven, whatever. So, because the landlord can deduct for cleaning, for unpaid rent, and for repairs. Tenants have a right to ask for a walkthrough inspection before they leave, with enough days that they can actually make the repairs or do what they need to themselves. And these cases usually go to small claims court. And that's it. Discrimination in housing is illegal. So discrimination can be based on disability. So a landlord says, nope, you absolutely can't have that emotional support animal. You absolutely, there's no way, I'm not going to, I have an absolute no pets policy. Like, no, really, I provided my medical provider's note saying that I should have an emotional support animal, and you don't have the right to say no. The Department of Fair Employment and Housing recently changed its name. It's now called the California Department of Civil Rights. The tenant can file a complaint there for disability discrimination. The Department of Civil Rights will also hear claims of race, color, religion, sex, sexual orientation, and other forms of discrimination. Gender orientation, I think I said that. National origin, and also immigration status is a protected status in California in housing rights. So there are specifically laws that say you cannot discriminate on the basis of immigration status. So a landlord doesn't have the right to threaten, to call immigration. They don't have the right to use that against a tenant in any manner whatsoever. And tenants should be able to apply for units and use a TIN or use just their birth dates and their names and other and prior landlord references, even if they don't have a social security number. In addition, there's relatively new within the last year or so source of income discrimination protections. That means that landlords cannot refuse to take Section 8 housing vouchers. It also means that landlords cannot refuse to take rental assistance from a third party. So we used to have a fair amount of problems where the landlord would be asking for their money. Catholic Charities or Salvation Army, some other agency would say, okay, we've got money, you know, we're willing to help this tenant, and the landlord would say, no, I'm not going to take it from them. And now that's illegal. That is housing discrimination, and the Department of Civil Rights will take a complaint. It's not a perfect system, it's a slow system, but it's there. So just remember that you would ask me to talk about that.
And Section 8 vouchers.
And Section 8 vouchers, right. So Section 8 vouchers, I'm sorry. So the landlords do need to take Section 8 vouchers. If their rent is within the range that Section 8 will cover, and Section 8 has housing authority that has been pretty proactive about making sure that their rents go up pretty regularly. So if somebody goes to a landlord and has a Section 8 voucher, and that landlord says, no, I don't do that, that is now source of income discrimination. It is illegal. That applies to all landlords. That applies to the landlord that has only one house that they're renting. That's the law. So, and I have a few pages on that in Spanish and English about source of income discrimination.
Thank you for that presentation. Now we're going to open it for a question and answer. Yes, and for Anna. Round of applause for Anna. And a round of applause for yourselves for coming out tonight.
And staying awake.
Right. So now's an opportunity for question and answers if there were.
A gentleman shared with me, un joven compartió una historia conmigo que vive en una casa que se los andan comiendo los termites, right? Pero nomás pagan bien poquito de renta, so no quieren llamarle la atención al landlord por las reparaciones, porque él ha escuchado que a lo mejor si son muchas reparaciones a lo mejor los sacan y pierden esa renta barata. ¿Qué pueden hacer ellos?
The question is that if somebody doesn't want to call the landlord because they live in a house full of that has termites, but the rent is so low that they don't want to tell the landlord because they don't want to risk losing that house.
So, multi-faceted question there. Thank you. On the one hand, the tenant has, like I say, the obligation to notify the landlord that there's damages ongoing to the house, because as termites spread and dry rot spreads, it gets worse and worse, and it increases the amount of damage to the house. At the same time, the landlord should not retaliate. So there's laws against retaliation. The landlord should not retaliate for the proper assertion of a legal right. So a legal right is the right to notify the landlord that some repairs need to be done, and if they do that properly, they do that, verbally, ideally in writing, so we have proof. If there is retaliation, then retaliation is illegal. If the landlord has to do major repairs on that unit, such that a permit has to be pulled in order to make those repairs, and it's going to take and it's going to take more than 30 days to make those repairs, then the landlord can issue a 60-day notice. But I will also say, about a year ago on this issue, here I asked nobody to share personal stories, and I'm going to. We had major repairs done on our house. We had siding pulled off, we had wood replaced, we had termites and dry rot replaced. It was frustrating, it was noisy, and we didn't move out of our house. We grinned and bared it, and we didn't have to pull permits. And so my rule of thumb is that if, as a homeowner, if I would continue living in my unit while those repairs are done, and then a tenant shouldn't have to vacate either. So, and I will share that was over $20,000 worth of repairs, which peeves me no end because I still have a messy driveway and I still have other things that I would love to have done on my house that would actually show for it. But I happen to know that a lot of repairs to dry rot and termites can be done without requiring that a tenant vacate.
¿Qué es lo que se está haciendo como para, de alguna manera, apoyar a las personas que se fue el incremento a las rentas, ¿verdad? Y han sido desalojadas? ¿De qué manera pudieran ayudar, especialmente a la gente que no tiene documentos?
So what are they doing to help the tenants that have been evicted? Their rent has been increased and due to that have been evicted. And what are they doing to the people that have no documents? How are they helping them?
So, if I can ask, who is they?
Hay varias personas que se han incrementado sus rentas y pues tienen que deshacerse de, porque ya no van a poder pagar sus rentas.
There's several people that have to leave their homes because the rent has been increased and they can't afford it.
So if that has taken place since, what was it, March 3rd of 2020, and the landlord increased the rent more than 10%, that violates the penal code, and they can report it to the district attorney's office. Also, the state attorney general has expressed interest in those cases and enforcing that penal code against landlords who have increased rent. So, so there's the criminal side of things, and then the tenants also can sue either in small claims court or through an attorney for their damages, for the increased rent that they have to pay, for the inconvenience of having to move, and for whatever charges they incurred because they were evicted for that improper reason. If it happened before 2020, so there's also something called the statutes of limitations, which put limits on how long you have to sue. So I'm not going to start figuring out the statute of limitations either at this time of night or in front of people, because I'm likely to do it incorrectly. But anyway, there's statutes of limitations, generally 4 years to sue on a written contract, 2 years on a verbal contract, generally 3 years on a statutory right. So it just depends on what's being asserted and how long.
What happens if the owner serves the tenants with a 60-day notice to vacate to improve their property, and once that's all done, is the owner able to increase their rent more than 10%? And is the owner obligated to offer the unit back to the previous tenant?
Okay, so first of all, we're assuming that that the work done on the unit is going to require that the owner pull permits. And it's going to take more than 30 days to do that work. then the landlord can terminate the tenancy with a 60-day written notice. They do have to either waive the last month's rent or return a month's rent within 15 days of giving the notice. If the tenant doesn't vacate within the 60 days, then that waived rent might be charged against the tenant in the court proceeding. But yeah, if the landlord, so let me be clear, if the landlord does everything right, then there are ways to properly go through with an eviction. But what I think often happens is there are some exceptions in that law, like that the landlord's going to take the property off the market. And, you know, how do you prove, oh yeah, I took it off the market for 3 days and then I decided to put it back on the market. So, you know, every law can be abused, unfortunately.
¿Qué pasa? Por ejemplo, yo estoy arrendando un apartamento y necesita arreglo. Y el dueño me dice, el mismo apartamento, ya arreglé esa unidad, deja el lugar aquí porque lo voy a arreglar, te voy a reubicar a otra unidad que ya arreglé, pero con otra cantidad más alta la renta y el depósito. ¿Sí hay algo que se puede hacer ahí o no? ¿O necesita?
So I think that if the landlord says that, okay, I've done repairs on this unit and you can move over here, but I'm going to raise the rent over in this other unit, I would say it's the same tenancy. And so I would say that the rent increase can't be more than whatever's the limit for that tenancy. I think there's a strong argument to be made. So I'll tell you, when every week we review all the cases that come into the office, and we have to discuss these things out and figure out what do we think is the best way to approach them, and decide, you know, can we make this argument, you know, and pretty much if I can go in front of the court and not have to just say this is unfair and stamp my foot, I'm going to look at whether or not that's a strong argument. Anytime we go to court, there's a risk that there's a risk we're going to lose, and then we need to decide, you know, so we need to make sure that we communicate that to our clients very carefully as to whether or not we, you know, how much risk they're taking by moving forward that way. Yeah.
Hay algo similar, parecido a lo que está presentando Jesús. Yo hoy conocí una familia que pagaban $1,900 de renta, $2,900 de renta, y les dijeron que iban a pintar la casa en un mes. So, pintaron la casa y ya cuando regresaron les subieron $1,000 de renta porque les dijeron que ya era otro dueño. Entonces, ¿eso es legal?
Este límite de 10% aplica si la residencia de los inquilinos dura desde un inquilino desde un dueño al otro. Si es la misma residencia con la misma inquilinos, no pienso que puedan aumentar la renta más de lo que está permitido por la ley, como hemos discutido todavía. So the question was, if there's a change in owners, but from one owner to the next owner, can the new owner raise the rent? And so my answer is that I think it's the same tenancy, it's the same tenants, but the change of ownership doesn't change the rights as it applies to those tenants. And sí hablo español.
But they can add fees, which happened to me, so they raised rent 10%, changed owners. Then the new owner didn't raise the rent, but charged me a $100 fee for garbage, sewer, stuff I wasn't paying for.
So When there's a change of expenses, so if the garbage and the sewer and the water were previously part of rent, and now there's an owner or a decision that now I'm going to charge a tenant separately for those utilities, we analyze that the same way we do a rent increase. Is that over 10%? Because, so if that's over the amount, you know, again, are we under an emergency order that 396 applies? Are we under the Tenant Protection Act because we're in multifamily housing? Or are we in single-family housing and nothing else applies? How much time? How much can the rent increase? Those are all the various factors we're looking at. Is it more than 15 years old? All of these different laws that are currently.
Yo tenía una pregunta acerca de cuando recibe uno una carta de desalojo, ¿es obligación del propietario regresarte el depósito de seguridad que dices?
So the owner has 21 days after a tenant vacates to return the unused portion of the security deposit with an itemized list of deductions from the security deposit. So and the deductions can only be for damages beyond regular normal wear and tear, and for unpaid rent or utilities, or for damages, rent, cleaning, or for cleaning. A landlord can deduct for cleaning, but then the rest of the security deposit does need to be returned to the tenant. So the carpet, how often does the carpet need to be changed? That's a really difficult question because the law doesn't address it. The law says that the floor has to be plain, so if it has to be flat, if there's a tripping hazard, if it's torn, if there's nails sticking up, you know, that becomes a little bit easier. If it's just dirty and ugly, if the paint is just dirty and ugly, if cabinets are just dirty and ugly, unfortunately the law doesn't cover that.
I'm going to give one more round of applause, please, to Phyllis. One last point of information. I did want to give Beatrice the opportunity to come up and talk about the rental registry if she wants. So I'll hand it over to Beatrice.
So I think I've been to some meetings with a lot of you have been part of, and I've talked briefly about the rental registration program. This is going to be presented to council on April 4th, but really where we want to get a lot of your input is on that design of services. What kind of services would you like to see in the community that right now are a gap? And you want the rental registry to be able to support providing those services. These are tenant landlord services, and some examples of them are mediation services, inquiries, and that means if you have a question that sounds more in the legal field, who can you call that can give you the best information, reliable information? Those are the inquiries. We can also do a little set-aside fund for emergencies, and this will require a lot of input from the community and a lot of support. But a show of hands, how many of you feel that we need more workshops like this that are tenant-landlord rights and responsibilities? What about a show of hands, mediation services? Mediation services, and an emergency fund that can be for someone that is getting evicted, someone that might not have enough money to pay their rent, like an emergency fund that we can resort to if somebody needs that in order to stay housed. Okay, so we will continue to do outreach around this topic. So if you hear rental registry and you're not sure what it is, this is what it is, and we really want your input into that program design.